All rise. The First District Court of Appeal is now in session. All who have business before this court, draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the Florida First District Court of Appeal. We have one case on the docket today, Matthew Nipper versus State of Florida. Counsel, when you're ready, you may proceed.
May it please the court, opposing counsel. My name is Melissa Ford. I'm here today on behalf of the appellant Matthew Nipper. A defendant has a Sixth Amendment and due process right to be present for the trial and confront the witnesses against him. And Mr. Nipper was denied that right when the state's case was presented without him there based upon a medical emergency. Mr. Nipper, the night before his trial, was rushed to the hospital after what the hospital staff team termed an apparent unintentional overdose. This was after his friend found him cold and blue at her house, 2 hours after she had left him there. Mr. Nipper endured CPR from his friend and also from EMTs who came to rescue him. So on the morning of his trial, he was not present.
Did the hospital indicate whether it was a drug overdose, alcohol overdose, or is that still ambiguous?
It was ambiguous. It's not in the record. In the report from the hospital said they termed it an unintentional overdose, and they said he was on COs, which they never said what it meant, but that they were alcohol protocols. And that, so the only thing that indicates drugs is there are CAD notes that say, quote, "it pops for meth." It's not clear from the record what popped for meth. Mr. Nipper was administered Narcan, but Narcan is used for opioid overdose. It's not really clear if that's what brought him back. So it does not seem from the reports, either the CAD notes or the reports, that Mr. Nipper had ingested methamphetamine. His breathing, when he was found basically blue and half dead, his breathing was really messed up. He had an acute kidney injury at the hospital. So we have some information about how he ended up in the hospital, and it wasn't really clear that the notes say an apparent unintentional drug overdose, but it's kind of not 100% what it was. He was having...
Would it make a difference, do you think? I mean, let's say it was just alcohol poisoning or whatever the official or medical terminology is for it.
It would not make a difference
compared to whether it was a meth overdose.
It would not make a difference. I realize that one of those substances is a legal substance and the other is not a legal substance. But generally, if someone is going to ingest any of those substances, and that renders them in need of medical attention in an emergency, I don't think that there's a difference. And the reason is because people engage in a lot of dangerous behaviors, perhaps particularly before they're going to a trial where they know that they may be put away for life. In Mr. Nipper's case, unlike some of these other cases that we're looking at, there's not a clear intent on his part to avoid his trial at all.
And let me ask a few questions
Sure.
on that point, because the state argues, to the trial court on the first day of trial that, this overdose is an attempt to get a continuance that you wouldn't grant before.
Right.
And correct. I just want to make sure I understand the record perfectly. As I see it, there in January 2022, there was an unopposed motion for continuance when there was a new counsel appointed for Mr. Nipper, correct?
Yes.
All right, and then about a week before trial, Nipper's counsel moved to continue to do some additional, interaction with witnesses that he believed were crucial to the defense. and that was denied. That motion was renewed before trial and denied again. Was there ever any indication in the record that Mr. Nipper, as opposed to his counsel, wished to postpone the trial?
I could not find such information. It appeared from the record that counsel was seeking additional time to look at some GPS records, to further interview a witness who new things had come out in that witness's deposition, and counsel was seeking additional time to further explore what Mr. Kester, the victim, had said during and he was slightly evasive in his answers, and counsel at that point thought, oh, wait, there may be more going on here. I've got to look at some other things in order to prepare this case.
Sure, but there's no record evidence that Mr. Nipper was trying to postpone the trial.
Not at all.
All right, and then from there, at jury selection, Mr. Nipper attended.
Yes.
And he was very active, was he not?
Yes.
So there's no indication that he was trying to, absent himself from that part of the trial.
Correct.
All right. So, and then as soon as it's the second day of trial, he checked out of the hospital AMA.
He did.
Right. So again, an indication that he wanted to be at trial.
Yes.
So let's assume, after the original motion to continue at trial, when Nipper's counsel renewed and moved for a new trial based on this evidence, what evidence would there be in this record that Mr. Nipper ever wanted to voluntarily absent himself from trial versus maybe voluntarily get drunk?
There is no evidence of that. So you can make a waiver, in court. You can just make your knowing voluntary waiver of your presence, and then stated in the rule and in the case law, you can voluntarily absent yourself by disruptive behavior. We've seen none of that in this case. Every time that anything is going on in the case, Mr. Nipper is there and is engaged, and there simply isn't any evidence that he was trying to delay the trial, that he was trying to manipulate the court.
And as far as the even the intentional absenting himself, or the alleged intentional absenting himself through an intentional overdose, don't the medical records suggest an unintentional overdose?
Yes.
All right. So is there any record evidence that shows that he was intentionally trying to put himself in the hospital, suffer kidney damage, and heart failure?
There is not. And several of the other cases that we've looked at in the briefs, some of them you find no medical documentation at all of what happened, and so, okay, that was voluntary. Some of them you find, there's a case, Edwards, where it was this complex RICO trial, and the defendant had to have heart surgery, and his doctor had recommended it, far in advance, and he decided not to pursue the treatment, and then suddenly, right in the middle, after the second day of trial, the Edwards defendant finally decided to go see the cardiologist. So you can see in that case that there were opportunities to get the medical help he needed, but then he chose to go to the hospital. Mr. Nipper never chose to overdose, never chose to go to the hospital, and exhibited, by all accounts in the record, a desire to be there. So it should not be a voluntary absence. It should be an involuntary absence.
How does one assess the difference between an intentional overdose and an unintentional overdose?
Well, in some other of these cases that we're looking at, you have, for example, a defendant...
I mean, is that like a medical thing, or is it just based on
I don't know in the medical profession what they would mean by an unintentional overdose. One way you might be able to tell someone had an intentional overdose is perhaps leaving a suicide note. So we've got one case we're looking at, and the court, in evaluating that, said that it was apparent that in trying to kill himself and leaving a suicide note, the defendant was making a choice to permanently absent himself from his trial. Now, he failed. And he said, that he's going to go out his way, and, he knows you've got me, but I'm going to go out my way. So there was evidence that he intended to overdose. So So, I mean, that, that would be an example. And then there's there's another case where it's an attempted
I just
suicide
meant,
by
I mean,
drugs.
when the hospital says there's evidence that indicates it was an unintentional overdose, I mean,
Yeah, I don't have the
that
medical background.
doesn't strike me as a medical assessment unless you know of some sort of way that doctors can.
I do not, so I would assume that the court should trust the professionals. I don't know what protocols they might go through to determine whether something was intentional or unintentional.
What if he did intend to overdose? Would that matter? Do you think?
I think it could matter in a situation like, as I am saying, with these cases where there's a suicide note and there's other supporting and corroborating evidence that shows that it was intentional.
Like, what if he overdosed, instead of it being the morning of trial or late night, early morning before trial, it was 2 days earlier, it was after jury selection on Monday, he goes home that night, ODs, intentionally says, this is his last, just gonna push it to the edge and see what happens. And he overdoses, but actually is revived. With enough time so that there's not as much, like, I'm trying to understand, is there a temporal element to it? The fact that it happened the night before trial, does it make a difference that it was the night before trial as opposed to 2 days earlier? What are the consequences where, like, he ODs, he's in the hospital, but he's still in the hospital 2 days later,
Right.
where it was possible that if he OD'd and got out of the hospital, he could still make the trial. I'm just trying to understand if you think timing matters.
I think timing can matter. In that particular hypothetical, it's hard to say whether it would matter, and I don't necessarily think that it would. I think that, perhaps the rest of us are not, well versed in, we've never been looking at life, PRR looking at life. We don't know these perhaps my last days being out of here. Was it perhaps careless? Yes, maybe it was careless, but I think that choosing how you're going to spend your last day before you go to trial and you're looking at a potential life sentence, there is a case that does give me some pause about timing. There was one defendant who, right before he was in the trial, right before his jury went to deliberate, he took a ton of antidepressants while they were out deliberating, and that was found to be a voluntary absence. So he's present in the courtroom. It seems pretty clear that he's trying to get out of being there. So this is a day before Mr. Nipper is coming in for his trial, and it's not a foreseen circumstance that if someone ingests drugs that they are going to overdose. It happens.
Counsel, let me ask you a question about the sequence of events in
Sure.
this case and how that impacts the intent analysis. So he didn't just, go to take some drugs. He got smacked on, tequila or whatever he was drinking. He drank until he didn't know what he was doing, arguably, and then he took the drugs. How do you parse out the intent analysis when there are sequential events, one of which would have been arguably more intentional than the other?
I don't think there's enough in the record for us to be able to 100% know for sure what the intent was. So your judgment is clouded at that time if you have been drinking, which the friend who found him said that he had been drinking, and then she left for 2 hours. So we're not sure what happened in those 2 hours. And so,
I mean, as it relates, you're the judge, and this is the information you're getting, and you've got the jury sitting here, and you're just, you got very short time to make a decision. Is it, completely unreasonable for the trial judge to have said, well, maybe he intentionally got drunk, and everything that followed from it was intentional as well?
I don't think so. I don't think that intentionally doing an act leads to intentionally going out of your way to, on purpose, not be at your trial.
What's the standard of review here?
Abuse of discretion.
Is it though? I mean, you cited in the brief, Capuzzo, but it's not entirely clear from at least that case that it was really, I mean, it was kind of like in passing talking about discretion. Can you think of another circumstance where someone's constitutional right is subject to the discretion of a trial court? I mean, if someone does a voluntary, they do a plea colloquy, does the trial court have the discretion to determine whether that person's giving up their right, their constitutional right?
I would say no. I mean, well, let's back it up. So the judge is hearing what's going on, the judge is doing the plea colloquy, and if they're behaving reasonably, they ask the question. You have an actual waiver in court. You have a colloquy that you go through, and you really ensure. And so if you follow that colloquy, you're unlikely to find an abuse of discretion.
Sure, but I mean, we do these reviews all the time as to whether it was a voluntary waiver, or the defendant knew what his right was and he relinquished that right voluntarily, et cetera. There's a variety of questions that the trial court asked. I don't really feel, but is our review really, did the trial court abuse its discretion, or is the discretion really how the trial court goes about assessing what happens? Like in this scenario,
yes,
the trial court had discretion whether to stop the trial or delay it to the afternoon so that the witnesses could come in versus doing it on the phone, and no one objected, by the way, to just having the nurse and the friend talk on the phone and submitting some of these records just kind of willy-nilly in court. No one objected to that, and the trial court presumably has discretion to do it that way. But when push comes to shove, and the trial court's, the question is, did the defendant voluntarily give up a known legal right? Is that a discretionary decision on the trial court? And do we look at it as, well, there's several possible reasonable outcomes and the judge chose one of those possible reasonable outcomes? Versus this is a constitutional right, and is it a little bit closer review?
I recognize that I could be in error in identifying abuse of discretion. The case law that I looked at told me that abuse of discretion is the standard I should be looking at in making this decision. So that is why I proceeded that way.
Let me parse that out a little bit. I think it's one thing to say that whether to continue a trial or not is abuse of discretion. Do you have a case that says, with regard to the decision about whether a defendant has voluntarily absented himself, where there's been analysis of the proper standard of review for that question?
In the cases that I reviewed, we don't get there, which to me is unfortunate, I think, because there should be a more onerous standard of review. I did find one case, unfortunately this was just briefly, and I did not want to pour it on the court at the last minute and do supplemental authorities, but I've got, of course I don't have it right here. I've got this case, MSW, I think, and I'll grab the site. But in that case, it was looking for whether there was competent substantial evidence to support the judge's decision. And they found that there was not, where the state had not had sort of any rebuttal to what the defense was saying. The defense is saying, hey, this is how this should go, and the state really said nothing. And if I could please reserve the rest of my time, I apologize for not doing that at first. I'm so sorry.
That's perfectly fine.
Thank you.
So noted.
Good morning. May it please the court, my name is David Welch. I represent the state of Florida in this case. It's our position that the court correctly ruled in this case that the appellant had voluntarily absented himself. As I think you've seen in both of our briefs, there's not any case law in Florida directly on point to here. But the case law does show is this is a case-by-case analysis that the judge has to make in terms of what did the defendant do? Why is he not there? And here, looking at the timeline, you were talking during the appellant's brief that, oh, he did the drugs the day before, he was drinking the day before. When you actually look at the timeline, this is about 6 hours before trial. When you look at the notes, he's admitted to the hospital, I think, at like 4:41, 4:40 a.m. The 911 call is logged at, I think, at 2:41 a.m. in the morning. So based on, I think it was Ms. Jenkins' testimony that the appellant arrived at her apartment and then approximately 2 hours later she found him non-responsive, that puts him in the apartment sometime after midnight. So he's already visibly intoxicated at this point. She mentioned that...
But he's not dead.
He's not dead, no. And that's, Judge, getting to my point is, maybe he didn't, he may not have formed the conscious thought of, I'm going to miss trial. But ultimately, no one forced him to drink. No one forced him to potentially do drugs.
But he has a right to drink, right? I mean, he has a right to party the night before he may go away for life.
Right, but then you also are now going to be responsible for your actions if you drink all the way up into 10 minutes before trial and then pass out and you're unconscious for trial. That's a result of your voluntary action.
Sure, Mr. James probably would have argued just drag him into court and have him sit there in the seat unconscious because we have our witnesses ready for trial.
Right, but that would be practically not having him there, because the point of having him there is, right of confrontation, potentially the assist of the cross-examination of witnesses. An unconscious defendant, it might as well be an absent defendant. But it's like, how did we get here? Because of the voluntary actions that he took.
Well, let's go to the transcript a little bit.
Okay.
When the state starts arguing right off the bat to the judge, he's taken alcohol and drugs and is trying to secure a continuance that you wouldn't grant. This is his indirect way of doing it. What evidence was there in this record that this defendant didn't want to go to trial and was trying to continue it versus his counsel's efforts to prepare?
Well, some of the evidence you have is Ms. Jenkins' testimony that, he had jury selection. 2 days later, trial starts. He's obviously nervous about trial, as is normal for defendants, and he took some negative actions to cope with that nervousness.
But what is nervousness? I mean, does that signal an intent to relinquish the trial right? Particularly in the context of this defendant sitting through jury selection and the next day checking himself out of the hospital against medical advice to participate in his trial. What evidence do you have of that voluntarily knowing relinquishment of the right to trial versus having some drinks before the night before trial?
Well, one, I would say this is obviously more than having some drinks, but also
how do you know that?
Well, basically,
going on to Judge Rowe's question. Don't guess. How do you know how many drinks he had, and how do you know what happened the night before?
Based on the evidence we have, is you have Ms. Jenkins say that when he initially showed up, she was already worried. Potentially he had already drove drunk to get there, because she says that she was very worried about him driving, and as she's leaving, she's like, just promise you're not going to drive. So he's already visibly intoxicated enough for her to infer that he's potentially over the legal limit. And then 2 hours later, he's passed out on the floor.
And what evidence, other than the CAD note on the methamphetamine, is there any not testimony, because nothing was sworn here, but any evidence of drug use, other than counsel arguing about it, the state, any evidence that there were drugs used and when they were used? Could he have had the meth before he started drinking? Do we know?
No, it's unclear based on the record of when potentially. The evidence would be the fact that they treated him with the Narcan, or the anti-overdose medicine, whatever it is, and the fact that it's all from the notes.
How long does meth stay in the system?
It's a relatively quick. I'm pulling back on my JAG days. It's a relatively fast half-life, but it's several days.
Right. So and that's not. And again, I recognize none of this is in the record, but.
Right.
The sole evidence we have of Mr. Nipper's drug use is that CAD notation. Everything else, our counsel going back and forth and the drug inquiring. If you can point me to something in the record, otherwise, that would be very helpful.
No, you're right, Your Honor, that it's the the notes and the 911 call. But ultimately, I believe it's when the defendant does not show up, it's the burden shifts to the defense to show that it was a voluntary absence.
Well, in the trial court, didn't the trial court focus for most of the preliminary part of the trial, before trial started, on whether Mr. Nipper could get out of the hospital and be at the trial? I mean, it seems several times the trial court asked,
Right.
if you can bring in some evidence or something to show that he can't leave the hospital, that hasn't been discharged or something like that, please bring it.
Right, and I believe that goes to the fact that it was the defense's burden at that point to show he's voluntary.
Weren't those records ultimately submitted? I mean, is there a dispute from is the state disputing his ability to unhook himself from whatever and to leave the hospital against medical advice?
Our position is because basically ultimately the actions that led to his hospitalization, the drinking, the potential drug use, there's no evidence that those were forced on him, that he did anything
but that wasn't the trial court's focus, at least initially.
Right, initially.
So the trial court tells the defense, okay, it's your burden. You have to show that he can't be here. So bring me something from the hospital or something that shows that he can't leave the hospital and that he's just not. Because I think the nurse originally said, well, they're waiting for the doctor to make his rounds and he hasn't gotten there yet. But then, lo and behold, there's a record that shows that he's actually in a bad way, and it's not just a matter of walking out of the hospital. And then the trial court, I guess, determines that that's not good enough. So what's...
Well, and I think you need to back up a little bit. Is initially defense says he doesn't know where the defendant is, which I'm not sure if that was 100% true, because Ms. Jenkins' testimony implied that defense counsel had already talked to her before they got on the record. But that's neither. Initially, it was just he wasn't there. He's potentially in the hospital, and there was no known reason for why he was in the hospital. So I think the judge's initial inclination was, all right, we got to figure out what's going on, and potentially, can we just go ahead and go forward with trial with maybe a short delay or whatever the case may be, of like, you've been hospitalized, but you can check out in 2 hours. Okay, we'll potentially continue it.
I thought the lawyer came right from the hospital and said, I got a call at 6:45 this morning. I went to the hospital. My client is there, and he can't get out because he almost died.
I think when they were initially on the record, like immediately, he's like, the judge says, "Where's your client?" He's like, "I don't know." And then they come back 10 minutes later, and he's like, "Okay, I have this the friend or whatever the relationship is on the phone, this Miss Jenkins." But once the judge, once it's determined he's in the hospital, then the question becomes, why is he in the hospital? And that's where the judge wants to look at the totality of the circumstances and make the call on if he thinks this is voluntary or not. And here, obviously, the judge focused on the fact that the evidence was basically he voluntarily drank and he potentially voluntarily took the drugs. And then, I think it was the Dofar v. State case with the hunger strike, where it's like, there's no indication that defendant wanted to miss his pretrial hearings, but the fact is he engaged in a hunger strike. And a reasonable outcome or foreseeable outcome of a hunger strike is if it's prolonged enough, eventually you're going to end up in the hospital. And so it's basically, is it a foreseeable consequence of his actions that he would end up missing trial? And here we have him showing up at this woman's apartment at midnight, 1 a.m., visibly intoxicated. And then 2 hours later, I don't know if he continued to drink or if he had just drank so much that it was just, I think it takes about 45 minutes for alcohol to fully metabolize in your system, that there was some kind of delay there. And then the evidence is that there's potential drug overdose. I know the medical records say involuntary overdose, but again, that's a medical record that was made, I think, the night of. It's not a legal conclusion. It was just a note.
Counsel, let me ask you, looking at this from the trial court's perspective, I don't envy him. This is just a dumpster fire. There's no time to get anything. The jury's sitting there, jeopardy's attached. What do you do? how stringent can we get on what kind of evidentiary standards we're going to impose on this trial court's decision, number one. Number two, if we say, well, okay, he got drunk, poor guy, you know, he has a tough life, he was nervous, let's continue the trial. Isn't everybody going to do that?
Exactly, Your Honor. Then that's why I say it's potentially, he may not have had that specific intention of like, I'm going to miss trial, but he had the intention to drink. He had the intention to do drugs. He's now responsible for the foreseeable consequences of those actions. And the fact that you drink to excess and potentially pass out, or take drugs and potentially overdose, if that happens, no one's going to say they're surprised that that occurred.
So anyone who takes drugs, so they take something that looks innocuous, but it's laced with fentanyl, they lose their jury trial right if they end up in the hospital. That's the rule of law.
Again, it's going to depend on the circumstances.
But you voluntarily ingest an illegal substance. That's my question. Is the state's position going to be, well, yeah, they didn't know that marijuana should have been just fine, but it had fentanyl. He ended up with kidney failure and cardiac arrest the next morning, but we're going to go ahead and continue with trial because it was, you know, you always know there's a chance the drug is going to be laced.
Probably not with marijuana specifically, because I'm not sure that's one you can actually overdose on. But,
no, I'm talking about contaminated. I mean,
right.
You know, anytime you take an illegal substance, there is a chance it's going to be contaminated, right?
Potentially, and
we read about it every day.
Right, but then it would be the defense's burden to show that it was a contaminated substance, because they're, again, once they're absent, it's defense burden to show that it's voluntary. So here, all we have is potentially he drank alcohol to excess and he took meth. There's no evidence that it was contaminated methamphetamine. It was just, all they have is it was meth. If the defense were to come in and say, like, well, you know, he took ecstasy and it had fentanyl in it, and it was just one, you know, but it's going to be a case-by-case basis. And here, again, we have him 6 hours or less before trial, drinking to excess, potentially, doing drugs. You know, even if he had an overdose, you know,
this is a constitutional right. I mean, you acknowledge that, right?
Right.
I mean, you have a right to confront your witnesses at trial, regardless. I mean, under the Florida Constitution, under the federal Constitution.
Right.
There's not a dispute about that.
It is a constitutional right, but
okay, so
again,
then
there's
what
also
what do you think the standard is for giving up or a waiver of a constitutional right, like the right to confront witnesses at trial? And is it a forfeiture or is it a waiver?
Well, it can be either or. I mean, it could be a waiver as occurred in the second day here, where he came back, he did testify at trial, so he was able to put on his defense, and then he waived his right for rebuttal, which I don't think there actually was any, but, you know, for closing arguments. But, you know, there can't be a waiver, you know, a specific waiver when you're not there. And so you could forfeit your right to trial if you're not there because of your voluntary actions.
Is that the standard? I mean, so anything that you do that results in you not being there is a forfeiture? So the consequence of you engaging in a bad act is you like your punishment is that you lose your constitutional right. Is that the argument? If we don't like what your behavior was, you were a bad boy, so you don't get the constitutional rights that other citizens get.
I don't know if I would go that far, Your Honor, because again, I'm sure I could think of plenty of examples where if you were speeding and your tire popped, potentially, that's not necessarily.
Well, what if his tire was already low and he knew that it was a bad tire and he's like, if I die today or if I get in an accident, like that's good for me because then I don't have to go to trial. I mean that's also a known consequence of a dumb action. Right.
But that would also be something, if potentially we could put on evidence that he basically said, Jesus, take the wheel, I'm just closing my eyes and driving and seeing what happens. I could see a scenario where you could argue it was voluntary. Like I said, he closed his eyes in traffic because he's like, I don't want to go to court.
But doesn't that turn, what is your definition of waiver? What do you think waiver is when it comes to a constitutional right?
Well, in this case, I think it's not necessarily a waiver. It's more forfeiture due to a direct result of his actions.
Well, what about the defendant who has, high blood pressure, heart condition, and does an all-nighter at Whataburger the night before his trial and ends up in the hospital with cardiac failure? That's obviously
Yeah, because that's an underlying, I think there you have an underlying medical condition that's, potentially beyond your control. And, eating a burger is not necessarily going to lead you to a heart attack on any specific day there.
Well, let's talk about, again, the standard. Does competent substantial evidence need to support the trial court's ruling? Do you need that?
I would say probably, because it goes back to the abuse of discretion for the judge. When I think what the standard there is, the judge, did they abuse their discretion when looking at all the factors to determine was this voluntary or involuntary absence?
But specifically, does it need to be competent substantial evidence? Or is, because much of what the judge heard here was unsworn, and you can walk through what evidence was actually before the judge.
And did anyone object to that?
There were no objections to any. I believe no one objected to any of the evidence in this case.
But when we're talking about a constitutional right, would that need to be preserved through objection? The evidentiary foundation for the judge's ruling.
Yes, but at the same time, you have to recall that this is a defense burden at this point. So it's, this is the evidence that the defense presented. So if the position is that this was not competent substantial evidence, then I think he has voluntarily waived, because it was, again, the defense burden to show that he was voluntarily absent.
I thought you said that it's forfeiture, not waiver, that the state was not arguing waiver. That the state is basically just arguing, these are the consequences of his bad act.
Right, and I apologize for maybe my semantics. What I was saying is it's not an express waiver as like he did on the second day, where he was in front of the court and said, I'm leaving, I understand the results of me leaving, what's going to be here. He basically, for lack of a better term, forfeited by not showing up to court, and then it's now the defense burden to show, okay, why is he not at court?
Well, and the defense did, that's where I'm going to, is you keep saying that the defense had the burden of showing something, and the defense did.
Well, and
several times.
Right, what
and
I'm saying.
now you're saying that that's not good enough, and now you're shifting and saying, well, forget that whole thing about voluntary waiver, because he didn't actually do a waiver. It's this forfeiture thing, because we don't like what the defendant did the night before, and he bears the consequences of his actions, including giving up his constitutional right to a trial.
Well, what I was saying, Judge, is if we're saying that this evidence here was not good enough, it's the evidence the defense presented. So either
what did the defense present? The defense presented
Miss
that
Jenkins,
he was in hospital.
He was in the hospital,
He
and
almost died.
due to alcohol intake and drug overdose.
Right. That's why he was not at trial, because he was in the hospital near death and he was being revived. Right?
Right.
And the doctor said you shouldn't go because that would be against your health interest, basically.
Is that all we look at, counsel, is just the end result? Or do we
No,
look at
no,
how
and
we got to
that's
where we are?
And when you look at the majority of the federal and state cases that have hospitalization, they basically say it's voluntary if you're hospitalized and you miss trial. One because he delayed medical, I think it was necessary spinal surgery or something. Another was overdose, another drug overdose. I think that was the Critz case, USV Critz. Ended up in the hospital.
Right, but if the defense actually takes the trial court's challenge and presents evidence as to why he's in the hospital and why he's not there, it's basically he's in the hospital and he can't get out, answers the judge's question on that. At what point does it shift to the state to show all this other stuff that as to how he got there, not guessing, but actually some evidence to show what his actions were?
I think it's all hand in hand, because it's not just because you're in the hospital doesn't mean you get an involuntary waiver to miss trial, because ultimately it's why are you in the hospital?
Right.
And
what did the state show as to why he was in the hospital?
Well, I think the state just piggybacked on the defense evidence here, because it was the defense that, when they put on the evidence, showed, well, he's in the hospital due to the drug overdose, due to the alcohol intake.
Possible overdose, right?
Right.
It could have also been a bad reaction to something he ingested, or it could have been a conflict,
It could have been, but then that would have been the defense burden to put that evidence on, that he had
Why?
a reaction.
Why is it the defense burden to then explain the state's unbased assertion that it was a drug overdose?
Well,
Disprove a false.
I think we're getting the cart before the horse here, because The defense burden is to show why he's not there.
And they did. He's not there because he's in the hospital. He almost died. And
Right.
unless the state's saying that he intended to die and the hospital interfered with that, which I don't see any indication of that.
I mean, he's in the hospital, okay, but why is he in the hospital? And the defense still has to show that, because again,
The defense has to show why he's in the hospital?
right, because just because you're in the hospital doesn't mean, I mean, if he had taken a gun to his head and said, I don't want to be in trial, and he was in and all they did was show he was in the hospital, that's still not
Was there a dispute as to why he was in the hospital? How he got there?
I mean, in terms
Was
of,
it an emergency medical incident?
it was
he
a
was transported to the
yeah, it
emergency
was in this case, it was a self-induced emergency medical situation.
And how do you know that?
Based on, extracting the evidence that the notes show, drug overdose, and Ms. Jenkins' testimony about the fact that he was visibly drunk, 6 hours before trial. And then, so it's one of those, circumstantial evidence of, if it's wet outside, it probably rained. Here, he was visibly intoxicated, and there's notes show a drug overdose, so he probably drank and took methamphetamines. If there are no other questions, the state asks that, based on the arguments today and our written response, that you uphold the appellant's convictions in this case. Thank you.
Thank you, counsel. I will extend appellant's time by 1 minute and 34 seconds and give the clerk a moment to do that.
Thank you, Your Honor. I want to try to address really quickly a few things that you all just talked about. We're talking about the timeline in him being admitted in the middle of the night. That has to do with what happened afterwards. So, I mean, whatever behavior began much earlier than that. Well, we don't know how much earlier than that, but probably approximately midnight it's according to the record, when he got to his friend's house.
So counsel, you would say that we should not be engaging in a but-for kind of backward-looking examination of what he did to start all this?
I agree, unless there is some evidence that it was with the intent to not attend his
And
trial.
how, under these circumstances, it's always going to come up suddenly, unexpectedly. Like I said, jeopardy's attached. You got the jury waiting. Under these circumstances, we just can't have, a 2-week evidentiary hearing with experts coming in and certified copies of records. I feel like the trial judge was kind of stuck here. What are they supposed to do?
I think that in looking at whether this, encourages others to, okay, I'm going to do something to try to get out of my trial, I think that there needs to be corroborating evidence that that's why they did the thing they did. We don't know also if Mr. Nipper had any underlying medical condition that was asked by the trial court, and counsel was unable to say so because all we really had was the report at the time, and he had acute kidney injury and he was having heart problem, presumably from chest compressions, which he mentioned when he did appear for his case.
Are we talking about, what about your colleague's assertion that, I'm not sure, I'm still not clear on the state's position on this, but this business about forfeiture versus waiver? Because it sounds more like the state and the trial court were engaged in more forfeiture, like, hey, you engaged in this other bad conduct, and the consequences, whether you knew you were giving up a constitutional right or not, we don't care, because you engaged in bad conduct, we don't approve of that, so you lose your constitutional right. It sounds a lot like a forfeiture, not a waiver.
Ordinarily, I would say that a forfeiture is going to be if you're in court and you're disrupting court and you're doing stuff and they, there is no waiver, but they have to kick you out because you're being so rowdy. There was one where he was just insulting everyone, calling the judge Hitler, screaming and yelling and rambling. That person had to be removed, and I call that more of a forfeiture. And here we're looking for a waiver, which you can have, per the rule, you can have by actually waiving voluntarily by yourself, or your actions can cause you to have waived.
Right. Doesn't the law abhor forfeitures, especially when it comes to constitutional rights?
Certainly. I mean,
And that's why we go through this whole thing like in plea colloquies. I mean, it takes, I know that trial court, it's tedious, but they're expected to do it.
Can I address something right before I run out of time? This case that I brought up, that I did not supplement the record with, I'm happy to supplement the record with it, and do supplemental briefing if you would like. The case is out of the 2nd DCA, Florida. It's MWG, and it says that it's the state's burden to present proof of a waiver.
What's the site on that?
The site, sure, is 945 Southern 2nd, 597, and it's 2nd DCA 2006. So I would just ask that you reverse the trial court, allow Mr. Nipper to have a trial where he can be present and discuss, as the witnesses are being questioned, what questions he thinks he need to be asked, because this was a really contentious case, about who said what happened, and his input is vital to have him there and able to speak to his lawyer. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.